All right, here we go again. So the Star Tribune has finally weighed in on the ongoing controversy regarding the Take Pride Act, which is part of the Judiciary and Public Safety Omnibus Bill that passed off the House floor just a few days ago. And just to recap, the controversy in question is that language was struck from the Human Rights Act that specified that a physical or sexual attachment to a child by an adult shall not be considered sexual orientation. And then there was an amendment to change that to it won't be considered as a protected class. Ultimately, both those forms of language were rejected. And what this does is it leaves a gaping hole in the definition, as I'll show you here. Once again, this is like the fifth or sixth time I've had to do this, that enables the interpretation in the future of basically pedophilia to potentially be regarded as a protected class in the state of Minnesota. And so let's break this down. And this is, by the way, written by Rochelle Olson. GOP lawmakers leveled a heavy accusation at the DFL majority during public safety debates in recent days, accusing them of protecting pedophiles, adults who are sexually attracted to children. A disproportionate amount of debate on the House and Senate over the 500 plus page $3.5 billion public safety bill focused on the removal of one sentence from the state's Human Rights Act. Quote, sexual orientation does not include a physical or sexual attachment to children by an adult. Now, you got to love this word disproportionate, right? So they're making it sound like, so what? We're supposed to measure out what proportion of the bill deals with a sexual or physical attachment to a child, and then only speak that long on that issue. I don't understand what the implication is here. Continuing, Representative Harry Niska from Ramsey said some may now interpret the HRA to deem pedophilia as a protected class in Minnesota, which prevents them from being denied employment, housing, education, and more. Now, that is an accurate statement, okay? That is a 100% accurate statement, and I'm going to show you specifically how and why. But before we get there, let's continue. The Star Tribune went lawyer shopping, and they found somebody to tell them exactly what they wanted to hear. That person is Jess Beaverman, legal director for Gender Justice. Imagine that. An incredibly unbiased source, right? A St. Paul nonprofit called GOP Complaints Manufactured Outrage. To protect pedophiles in the HRA, the legislature would have to specifically add them as a class, Beaverman said. Now, this right there just isn't true, right? So let's go and let's transition here from this article to looking at the actual bill. And this is what they don't want you to do. This is what they're counting on you not doing, is actually just looking at the bill and looking at the existing language. Now, if you've never looked at a bill before, understand that a lot of times the way it works is by stating that they're going to take existing statute language, which is printed here, and they're either going to add words to it, and that's indicated by underlining a word. That's adding language to existing statute. And then the other thing that they'll do is they'll cross language out, and that's taking existing language and removing it from the provision. So if you take a look at this paragraph, this is the definition of sexual orientation in the Human Rights Act. And it reads, sexual orientation means having or being perceived as having an emotional, physical, or sexual attachment to another person without regard to the sex of that person, or having or being perceived as having an orientation for such attachment. Now, the language that they want to strike is the language that follows, and that says, or having or being perceived as having a self-image or identity not traditionally associated with one's biological maleness or femaleness. Okay, so that's, by the way, that's a sentence unto itself that's worthy of some scrutiny. But it's eclipsed by the last sentence that they're striking, which is that sexual orientation does not include a physical or sexual attachment to a child by an adult. Now, consider this. Because one of the arguments, or the argument that's being offered for why it's appropriate to strike this language is that, well, of course, pedophilia isn't a sexual orientation. We all agree that pedophilia isn't a sexual orientation. So why should we bother to have language in law that indicates that? Well, because the words that are in the law matter, right? This is a definition. What this section of law does, what this provision does, is it defines sexual orientation. And it says that sexual orientation means having or being perceived as having an emotional or physical or sexual attachment to another person, to another person. Now, let me ask you, and this should be a very easy question to answer. Is the word person inclusive of children? Put another way, are children people? Now, we know the answer to that question is yes. We know that the word person is inclusive of children. And if you didn't want children to be considered as part of this definition, then you could have used another word. You could have used the word adult, right? If you use the word adult, then you could say, because that's another way we could amend this, right? Like going back to the bill. If you wanted to strike this language down here, and then also strike the word person up here and then over here and replace person with adult, then we'd be cooking with gas, right? Then you could say that we're actually taking some action to both deal with this supposed harmful trope of pedophilia being considered somehow attached to the LGBT uh, panacea of or panorama of identities, um, while also protecting kids. But they don't want to do that, right? They don't want to do that because if you were to do that, if you were to go in here and change another person to adult, then what that would imply is that you cannot have a sexual orientation, or at least that in the law, the concept of sexual orientation wouldn't apply to children. And we all know that they very, very much want the concept of sexual orientation to apply to children. So they're not going to strike person and replace it with adult. They're going to keep that. But by doing so, what that means is that unless you have this language, if you don't have this language that specifies that sexual orientation does not include a physical or sexual attachment to children by an adult, without that language, then sexual attachment to another person, by definition, becomes inclusive of sexual, physical attachment, emotional attachment to a child by an adult. I mean, it's plain as day. It's right there. So what this lawyer is saying, this gender justice lawyer, who we're supposed to trust for some reason, and certainly who the Star Tribune is apparently turning to for advice, this idea that to protect pedophiles in the HRA, the legislature would have to specifically add them as a class. No, they would not. By the plain reading of the law as it stands, when you take this language out, the HRA could very well be read as protecting people who have a physical or sexual attachment to a child as an adult, because that is included in the word person. They found another dingbat lawyer to quote here, Mike Stinson, professor of law at Mitchell Hamlin School of Law, agreed with Beaverman. This doesn't create some sort of broad-based protection for those who prey on minors. And you see how they're being a little too cute by half here, right? Because the law won't explicitly create that protection, they're pretending as though there's no implicit effect of removing that language from law, which there obviously is. Moving on, as for the potential for Minnesota judges to find that by removing that language, the legislature's intent was to protect pedophiles, Stinson said, I can't imagine any court would interpret it this way. Oh, well, I'm glad we're depending upon Stinson's imagination for our forecasting of potential legal developments. And look, this whole approach to talking about this, of, oh, don't worry, I can't imagine anything like that ever happening. Oh, you guys are employing the slippery slope argument, yada, yada, yada. Well, forgive me. I have a 14-year-old son. And when he was born, the president of the United States had campaigned just 1 year earlier on the concept of traditional marriage. That was Barack Obama. And now here we are 14 years later. He's about to have his 15th birthday. And we've got a transgender state representative who has authored, introduced, and passed and had signed into law legislation which cancels the parental rights of parents outside the state of Minnesota so that their kids can be brought here against their will to be poisoned and mutilated in order to affirm a lie. So the slippery slope argument isn't an argument, it's an observation. We can see that when you remove these goalposts in law, there's a trajectory to where you are going, and it is a forecast of things to come. And so it is entirely legitimate to look at the actual effect of the language that you are either introducing or removing from law, and what that enables and how it can be argued, and the overall trajectory of where it is going. That is a valid consideration. And the fact that the Star Tribune is wading into this debate, and taking the side of the people who are removing protections against pedophilia for the sake of our children is gross. It's gross, but it's also a sign that we're winning, because they wouldn't have to do that if our message wasn't getting out and it wasn't gaining traction. So thanks, Star Tribune. Thanks for providing me fodder for another reaction video. Take care.